First of all, I just want to say, one of you left some Honda keys at the front. I just want to make sure I get those to you. Okay. So now it's my pleasure to introduce our speaker, Heather Vrieze. Heather is a partner with the law offices of Vrieze and Kearney's here as well, here in West Seattle. Her practice focuses on wills, trusts, probate, and elder law. She's a frequent presenter on the topics that we're going to be addressing today, as well as a speaker on powers of attorney, medical directives, and elder law issues. And it's very appropriate to have Heather here speaking to a West Seattle audience. She grew up on Vashon Island, she attended West Seattle High School, and she's a graduate of Seattle University School of Law. So thanks, Heather, for all you do to support the West Seattle community and so for generously sharing your expertise today. Really appreciate it.
So I know that you guys are here for lunch. I'm here to talk to you before you get to eat, so I will try and keep this interesting and engaging and hopefully answer a number of the questions that you showed up with here today. If you find that the questions aren't answered in this first part, you're certainly welcome to talk to me at lunch. I think there may be a plan for some question and answer after lunch, but hopefully by through the course of this morning session, before lunch session, many of your questions will be answered, and so hold out if I seem like I'm glossing over something that you wanted more about, I may dip back into it later. The first bit is about who needs a will. How many people here have signed a will at some point in their life? Quite a number, not everybody, but quite a number of you. When was the last time you looked at your will? It's important to make a will, but also to keep it current. Pretty much everybody needs a will. If you own anything, or you have people or organizations in your life that you care about, that you would want to leave any assets to, not very many youngsters in this room who might have small children. When youngsters have small children, they need to have a will, because leaving the guardianship and care of their minors up to the courts to decide is never a good plan. Most of the backups, if you don't make a plan, most of the defaults will be the court will make a plan for you, the legislature will make a plan for you. And while I'm sure we can all find something good that they do, making plans for our personal lives, for the distribution of our assets, is usually not something we would leave up to the legislature, or that we would want to leave up to the courts, right? So, a will, in order to be valid, isn't very complicated. It has to be in writing. It has to state your wishes. It ought to name an executor or a personal representative, we call them in Washington. It needs to be, like I said, in writing. It has to be witnessed by two people who can attest to the fact that you know what you're doing, that you aren't being coerced, that you have asked them to be a witness, that it all happens in the presence, all three people, the testator, and both of the witnesses have to sign the will in each other's presence. That's not particularly complicated, but there's a formality to it that has to be followed, and the lacking of any one of those things can make the will not worth the paper it's written on. Usually, in our office, I try and make a will signing a fairly formal event. We invite a witness in, we ask the questions. Usually, I forego the, are you over 18? Because mostly that gets a lot of jokes, particularly from my clients who are your ages. Maybe the 25-year-old might appreciate that, or even the 35-year-old, but at some point, are you over 18 seems a little silly. But you have to be over 18 to make a will. Youngsters can't sign contracts. Under 18, they can't own property, and they can't sign a will. The other thing you have to be is you have to be competent. You have to know who you are, who the natural heirs of your bounty are, which means who's your family. There's a little chart in your packet about who would inherit from you if you didn't have a will. If you don't make a plan, that's the plan the state makes for you. You have to have a general understanding of, oh, oh, my spouse or my kids, my brothers and sisters or nieces and nephews might be the folks who would inherit from me if I don't make a will. So knowing that, choosing to do something different, is part of capacity to make a will. You have to have capacity to make a will in order to have a will be valid. The witnesses also have to attest to the fact that you're not acting under duress or menace or undue influence. Nobody's arm twisting or forcing you to sign something that you don't really want to sign, that you don't understand, that you don't feel comfortable with. I generally don't, never say never. I generally don't allow anybody who's standing to benefit from the will, other than a spouse who's also signing their will at the same time, to be in the room when we sign the will. Doesn't mean they can't be unduly influencing from the lobby, but if they're not there in the office and the client has the opportunity to say to me, oh, well, Jimmy out there is really pushing me to get this signed because if he doesn't get the house, he's not going to keep living with me and taking care of me. These are things I need to know because I need to know that a client is acting of their own capacity, their own free will, their own wishes and intentions when they're signing their will. So the requirements to make a will aren't very complicated, but there are lots of reasons that you go see an attorney to make a will. There's lots of reasons you don't just, in the olden days, go to the stationery store and buy a form, fill in the blanks, right? I type your name in or you hand print it in nice and neatly. Hereby state that I'm over 18 and competent to make a will. When I die, I want my assets to go to, a few blank lines. You can do that, but there's no substitute for the legal advice that going to an attorney who hears your whole situation, who understands what your family dynamics are, who understands what your wishes for charitable giving are, that understands who you really trust to jump in and manage things for you when you can't or when you pass. And that is something that no form, no program, no online fill-in-the-blank LegalZoom or the like will do for you, and what you do get from seeing an attorney. That doesn't mean it has to be complicated. It doesn't mean that it has to be difficult or expensive to get your will done with an attorney. Most of the clients that I prepare wills for, we handle in a couple hours, maybe maximum of a 2-hour appointment to start, and a phone call or a couple of emails in the meantime, and then a short meeting to get everything signed at the end. It can happen all in one day when I have a client who's getting ready to go in for surgery and just realized that they didn't have this in order or it hadn't been updated. We can do it very, in a rushed manner, but even when we're doing it in a relaxed manner, it doesn't usually take more than a couple of weeks. You have a chance to review documents and ask questions. No LegalZoom is going to give you answers to your specific questions about what does this sentence in my will mean, and an attorney can do that for you. And ultimately, because this is your last will and testament, your last statement of what you want to happen to what you have accumulated during your lifetime, for the people that you want to take care of, for the charities that you want to give to, it's really important that it be well thought out, that you understand what you're signing, and that it be your wishes, and you get all your questions answered. And you get that with an attorney. That's why to see an attorney and not just go online and fill out a form. The other thing, and not so much the point of this seminar, but it's important to realize that other documents besides the will are equally important, maybe more important, because they govern things while you're still alive. And you might care. When you're dead, maybe you don't care so much anymore. But if you have any period of incapacity at the end of your life, if you die suddenly in a car accident, or you die in your sleep while having been active and engaged the day before, maybe you don't need these documents, but for most of us, there's some period of time. It may be days, it may be weeks, it can be months, and in certain circumstances, it's years, where we can't manage our own decisions, we can't manage our own finances or personal affairs anymore. If you don't want to leave it up to the court, a power of attorney is the way you set up ahead of time. Here is who I trust to manage my affairs for me. Here is who I know will make the decisions that I would have made, who will be responsible and not thinking about their own bottom line and how they can benefit themselves from my estate. Here is who I trust to jump in and step into my shoes and handle all of my things for me as if it was me when I can't. Whether that's making medical decisions or whether that's keeping the property taxes on the house current and the insurance paid, deciding when and whether to sell the car or the house because long-term care in a nursing home or assisted living is required. You want somebody you trust. And the court's process for that is terribly expensive. And your private business suddenly becomes public record. All court files are public record unless there's a very particular reason we need to file them in a sealed file. Anyone with an afternoon off and bus fare can go sit down at the courthouse and look at records of guardianships. Guardianships are what happens when you don't have a power of attorney. A power of attorney is an easy document to prepare and something that I prepare virtually every time I help a client with a will. We also do a living will. That, one of those terms that means a lot of different things to different people, I call it an advanced medical directive because that's the most descriptive term for it. Stating what your wishes are for medical treatment when you can't tell the doctors or your family what you want anymore. Having it in writing ahead of time, whether you want to be intubated, whether you want to have artificial feeding or hydration, whether you want to be kept alive when your body is still going, but when you're not able to direct your care anymore. That advanced medical directive is critically important. And again, in some ways, maybe more important to you than the will because it affects things while you're still alive. When I talk about estate planning, I'm talking about all of those documents. Not financial planning. You go to your financial advisor for help on which stocks or bonds to buy or whether to have an annuity or whether long-term care insurance is something you can afford or not. I can talk about how the long-term care insurance might impact your plan, how it might impact what you will be able to leave behind for your family or for your friends or for your charity. But the actual sale of those policies, the decision of whether you can afford it or whether you qualify for them, that's something that you do through a financial planner. I'm not talking about that when I talk about estate planning. I'm talking about these legal documents that keep your business out of the courts. So how often should you update a will? That was sort of back to that. When did you last look at it? I usually recommend that folks review their will, pull it out and read it. Make sure that the people that are named in it are still important people in their lives, whether that's somebody who's going to be your executor or whether that's somebody you're going to leave assets to. You want to review that every couple of years at a minimum. That doesn't mean you need to pay the attorney to look at it with you. That should happen probably about every 10 years. Why? Even if all the family members are the same, even if all of your beneficiaries are the same, you still want the same executor. Back to the legislature, they change things all the time. And things that worked just fine 10 years ago may not work just fine now and may make your situation more complicated. It doesn't mean that your documents go out of date or won't be valid, but they may not be the most efficient and effective way to accomplish your goals and your wishes. And so that periodic review with your attorney is important. When I have folks with, back to the youngsters, those minors who need guardians or trustees, oftentimes those relationships change so much more quickly. Children grow up and who you might name as a guardian for a 2-year-old might be very different than who you name as a 12-year-old. So I oftentimes tell folks, well, just make up a list of all the people who are named in your will. When anything changes in any of their worlds, one of them dies or becomes incapacitated or gets divorced or has a bankruptcy or has some trouble with the law, anytime something happens in one of their lives, it's a good time to pull it out and review. And that might not equate to every 2 years or every 5 years or every 10 years, but those are the important things to keep in mind when you review your will. How much has changed in the lives of these people that I'm entrusting to make decisions for me? Maybe this charity that was really important to me 10 years ago hasn't had any involvement in my life in the last 3 or 5 years. Maybe I've got some other charities I'd like to get in there instead. Those things change periodically, and for you to make sure that it always matches your wishes is really important. Sometimes I'll find folks say, well, you know, I just sort of have to, I can't quite decide what I want right now because I'm not intending to die for a number of years, and I'm going to get closer, you know, wait until it's more relevant. Life gets in the way. Life jumps up and surprises us with all sorts of things. It's always a good idea to have the best plan that you can get on paper for right now and change it when circumstances change. A good plan is easily adjusted. Come see the attorney. Most of the time I pull the documents up in my computer if I drafted them for you in the first place. We type in the new names. We take out that trust that was for your 21-year-old kid who's now 41 and doesn't need it anymore. And we spit out the documents and we have a little signing ceremony and you have a new will that matches your wishes for that point in time. But it is important to review and to keep those current and to keep your wishes matching what your will says as often as your wishes change. There's a lot of times when, I'd say half of the clients who come in to see me come in and I start talking to them about a will and they say, well, what about a trust? Don't I need a trust? Or shouldn't I just have my kid as joint on my bank account? Or shouldn't I just have a beneficiary on my account? That it will take care of it, and then I don't need this will and probate. Well, first of all, I tell folks, probate is one of those bad words that got a really bad reputation because years ago, it was a cumbersome process that was governed by court administration. Nothing happened. No bill got paid, no matter how small, without a court order. Some number of years ago, before I started practicing, and that's been a while, back in the 80s, the legislature said, well, this isn't working for us anymore. People hate probate. People aren't doing probate. People are coming up with all sorts of tricky ways to avoid probate that are causing them other problems. We need a solution. Legislators in several other states and attorneys and judges got together and they said, we have to have a plan that protects creditors, protects beneficiaries, protects the will that you have drafted so that it doesn't get undone in court, but makes the process simpler, makes it less expensive, makes it relatively quick and easy for your wishes to be carried out. And 19 states now, including Washington, have what is called the Uniform Probate Code, or something that is very closely resembling the Uniform Probate Code. It's the simplest plan they could come up with so that a court, generally the process in Washington works so that a court looks at your will. They have to have the original. Copies don't count. I was in court just last Friday, and some gentleman, probably in his 50s or 60s, was there with 4 or 5 photocopies of his mother's will, trying to get the judge to acknowledge, because he had so many copies, because he was pretty sure he'd found all of them, that must be good enough. And the judge basically said, no. Original wills are the only proof that you haven't changed your mind. If you have a will that says something you don't want, all you have to do is throw it in the fireplace, tear it up, and that will goes away. And so putting the original in a safe place. How many of you who have wills know where your will is? The original. How many of your executors know where that safe place is? Also important. Because you know where it is doesn't mean that the executor can find it easily. And if they can't find it, it's as if you didn't have one. They can spend weeks or months looking through your documents, looking through your papers, wondering whether you had a safe deposit box at Key Bank or at US Bank, or maybe it was at Bank of America. And trying to get a hold of your will can be one of the most frustrating things for an executor or for a family when someone has died. Making sure that you know where that original is and that you leave them clear instructions on how to find it is really important. So I'll go down to the court with that original will, with your death certificate, because the court usually wants proof that you really have passed on. It only takes a couple of bad apples to spoil the whole bushel, they say. And within the last 3 or 5 years, the court started requiring that a certified death certificate be presented with the will, because some gentleman went down to court and probated his wife's estate, got all the assets put in his name. And when she got back from Arizona, she went down there to spend the winter with her son. She was not very happy about that. And the court said, oh my goodness, how could we have helped perpetrate this fraud? We need a plan. We need to be more careful. And the result is that we have to have a certified death certificate. That can delay probate by a couple of weeks, but it's not a huge impediment. It's just something that folks need to realize. Original wills, original death certificates, and the executor's acknowledgement that they're the one who's named in the will, that they want to serve, that they're able to serve, over 18, competent. And that will allow a judge to look at the paperwork and say, yeah, this looks like something that we should allow to go forward. And that is the last time a judge will look at your will or anything in your probate file unless there's a fight. If one child is written out of the will and wants to come challenge it, it can end up back in front of a judge. If a creditor didn't get paid and isn't very happy about it, it can get back in front of a judge. But we don't have the court supervised probates anymore. And so probate is really very simple. It can get started within a couple of weeks. It can be finished within a couple or few months. Usually 4 to 6 months is about the short end of the process. The thing that makes it take longer, property. We have houses full of stuff. And it can take your kids, your family or friends, or even a professional executor, weeks or months to sort through your belongings and get that house ready for sale. Another thing that can take a long time, taxes. When the IRS or the state of Washington want their fair share because you have a large estate, that can take longer. Because the taxes aren't due until 9 months after death, most of the time we don't pay it until 9 months after death. And that means that estates don't get wrapped up until at least 9 months after death. But that is, again, not a court process. It's something that the executor that you have named, the person that you trust, who might be a child who lives nearby, or a neighbor, or a friend, or a professional, they handle that because you named them and you indicated that you trusted them to jump in and settle your affairs. Make sure that all of the sort of money and paperwork of your life got wrapped up, and that your will, your wishes as stated in your will were followed. Everybody named in the will is going to get notification that the process is underway, so they have an opportunity to jump in and stick up for their rights or ask for things that they might be in. Well, you remember that little secretary that was, in Grandpa's hallway? I really kind of like that. Those sorts of things are the process of probate. It really is very little court process and very much about beneficiaries and family members figuring out what to do with all your belongings. And because those are oftentimes not the money part goes pretty smoothly. It's the dealing with the stuff and dealing with the house that can take a long time. How can you make that easier? You can clear out some of it now. You can downsize while you're still able to sort through your belongings yourself. You can, I heard some woman over here talking about scrapbooking, getting the important stuff together and getting rid of the rest of it. And trying to consolidate the 75 photo albums of vacations into a few important pictures. Because most of your kids don't really want to look through all those photographs of you with people they don't know at airports or restaurants that they have no idea what city it's in, or if it's important, going through it and pulling it aside ahead of time for them, leaving information about what is important to you so that they know, and it can be important to them. If they don't know what it is, it's not important and it's not useful. One of the other things that I often suggest to folks, and Washington law allows, and we put in every will, you can leave separate outside of the will. The lawyer doesn't write up, and grandma's tea set goes to cousin Nellie. And that doesn't go in the will, that goes in your own separate instructions. And so those are the sorts of things that you can do in your own time as you realize things that are important to particular friends or family members. More often than not, what I find is that there are things that mean a lot to people, and that the things are what people end up fighting over more than the money. And so if there are things that are important to you that you want to make sure go to particular beneficiaries, leave them the story of that information. Leave them written list that says they get those particular things because you know that those particular things will be important to them, will be valued by them when you're not here to tell them about it anymore, when you're not here to enjoy it yourself. So back to the issue of avoiding probate and trusts. Trusts are another vehicle to describe what you want to have happen to your estate after you die. It is not better or worse than what you might have in a will, it's just different. In some places, California still has those court-supervised probates. So if you have property in California, you need more than just a will. But if your property is here in Washington, a will is going to generally be the simplest way to administer your estate, the simplest way to leave your instructions behind, the most easily changed. Tear it up when you decide you don't want it anymore, make a new one. I don't generally recommend living trusts for clients in Washington, but everybody's situation is different, and that's why you come talk to an attorney to get your questions answered about whether a trust is right for you or whether you can do just fine with a will. You can go online and there are document companies out there that will help you put together a living trust, but they're not going to give you advice on whether that's the right thing for you or how it's going to work for your particular estate. When folks talk to me about putting children on bank accounts, it's one of those things that when it works just fine, it can be just fine, but when it doesn't, it can be a disaster. I had a client, it's probably been 5 or 6 years ago now. She came in with the weight of the world on her shoulders, and she sat down in my office and she said, "Heather, I need you to start a lawsuit for me." "What's going on?" "I need you to sue the IRS." "Oh, that sounds like a big problem. Tell me more about this, because I'm not sure I'm the right attorney for you." She said, "They took $19,000 out of my checking account." She had put her son as a joint owner on her checking account. Her son didn't file his taxes on time, didn't pay his taxes on time, and his name's on the account. And when they got an order to garnish his assets, they could come take money out of his bank account that was really her money. Putting children on a bank account can cause problems. Oftentimes I'll suggest have a little account, not the money that you need for your daily living, but $3,000 or $5,000 in an account that will provide immediate cash. Talked about a couple of weeks to get that death certificate and start probate. Maybe enough dollars to handle that intermediary time so that your kids or your executor can keep paying the bills, can make sure that your services, whether it's cremation or burial or any church services that are going to happen after your death, to make sure that those can be paid for without somebody having to fork over their own money. But it usually doesn't do to be putting your children or the folks that you intend to benefit from your estate when you die on your bank accounts while you're alive. That said, there's a lot of room for naming beneficiaries. Not joint owners, not current, also, 2, 3, 4 names on an account, but beneficiaries. The most important places to have beneficiaries are on your retirement accounts. 401ks, IRAs, 403bs, SEPs, Simples. They have lots of acronyms and numbers that tell us about these accounts. Those accounts need to have beneficiaries because taxes. Most of those accounts are accounts where when you pull money out of them, you will pay taxes. Income taxes on money that hasn't yet been subject to income tax. Your beneficiaries will also pay income taxes on that. But if your beneficiaries aren't named on the account, they have to take the money all at once and pay taxes all at once. And that can be a much larger tax hit than seems fair, or than any of them are going to want to have to pay. When I have folks who want to put their kids as beneficiaries on all of their accounts, that can work if they don't have any property. But as soon as you have property that's going to need to be maintained, your executor is going to need money to maintain it and to get it cleaned out and to get it ready for sale. And if your kids or charities are beneficiaries on all of your financial accounts, there won't be cash in your estate to make sure that that happens. So really good to have beneficiaries on the retirement stuff, life insurance, good to have beneficiaries, but not on every bank account and not on every financial or stock brokerage account, because that can, whatever we put in the will won't be carried out because you've named beneficiaries, and they're not going to look at the will, they're just going to look at the beneficiary designation. We're doing time-wise, so I've got about 10 minutes.
Okay, you're good.
So, one of the reasons we're here today is not just to talk about wills, but to talk about charitable giving. How many of you have donated to charity in the last year? Any charitable organization? Pretty much everybody. Why do you make donations to charity? Any answers?
Hope you they need it. Reduction on your
They need it.
taxes.
What's that?
Reduce your taxes.
Get a tax deduction. Makes us feel good. That's sort of our civic responsibility. You know, we feel good when we donate to Toys for Tots or when we put money in the basket at church on the weekend. We feel like it's something that we should do. For some folks, those are also good reasons to give at death. There are still reasons to feel good about. A lot of times we give to the church, or we give to the Humane Society, or we give to the Historical Society during our lives, but can't afford to give them as much as we think we would like to. We'd like to give more money, but we're worried that we might need that money later. Well, if I have to go into the Kenny, I don't want to be out of money when I can't give it all away. And that is a very, very reasonable reason not to give all your money away while you're alive, but also a very good reason to include those donations in your will, in your trust, on your beneficiary designations for your retirement accounts. For some folks, it's tax savings. Tax savings is a big reason to give to charity. It's one of the reasons that most charitable organizations fight the legislature, fight Congress when they start talking about getting rid of all those itemized deductions for giving to charity.
Right.
Because many of us like to give, but like to feel like we're getting something in return. Tax deductions are a good reason while we're alive. When we die, if our estates are large enough that they'll be subject to federal or Washington state estate tax, those estate taxes can start at 10%. When you get up to really large estates, it can be as high as 45% of your estate. Guess what? They don't tax amounts going to charity. So if you have a large estate, how much do the kids really need anyway? Do they need $10 million? Do they need $5 million? You probably worked for most of your money and maybe don't need to give that much to the kids. Giving it to charity, saving the taxes, can be a very efficient way to, let's say, folks who pay estate tax are being charitable, just not to charities of their choosing. When the federal government decides how to spend your tax dollars, some of those may be for charitable endeavors. Most of it's going to pay for military and all sorts of other things that we may not be very fond of. When you give to charity, it may be the same amount left going to your kids that would go if you had paid taxes instead, but you're giving to causes that you care about. You're giving to organizations in your community that you know will benefit from it in the long run. So the tax deduction is valuable, but the choosing where your dollars go is just as important, or is a good additional excuse besides tax deductions. As far as retirement accounts go, back to the tax savings, when you name a charity as the beneficiary of your retirement account, or as a beneficiary of part of your retirement account, they do not pay income taxes. So they get more dollars than if you had given that account to your children or to your neighbor or to your spouse. I don't necessarily recommend giving your retirement account to charity over your spouse unless your spouse can afford it. But you can name a charity as a backup beneficiary, contingent beneficiary, secondary beneficiary. Most of those accounts have beneficiary forms that give you a place to fill in who your first choice of beneficiary is and who a backup is. Many folks really want their kids to be those primary beneficiaries, but could very much afford to have the charities be backup beneficiaries. There's lots of ways to incorporate charitable organizations into your beneficiary designations. And when I work with clients to do their estate plan, help with filling out those beneficiary forms, not only when we meet, but 2 years later, 3 years later, 5 years later, When a new beneficiary form needs to be completed, that is part of the flat fee that I charge, because those beneficiary designations are such an important part of your overall plan and really necessary to make sure that what we put in the will works for the long haul. What you put in the will isn't going to be undone by something that ends up in a beneficiary form that wasn't what you thought it was. Or every company has their own version of a beneficiary designation form. Many of them are terribly confusing, have checkboxes that only lawyers can understand and not even us sometimes. And so it's important to make sure that you get help in filling those out. Sometimes financial advisors are good helpers for that, but the attorney's always a good source for how to fill out your beneficiary forms so that it works with your overall estate plan. There are other ways you can give to charity in your will. You can say, well, gee, I'd really like to give $100,000 in my will to church or to the Y or whatever your charity of choice is. You're not sure if you're going to have $100,000 when you die. Maybe it's better to leave them a percentage. I want to give 10% of my estate to these two charities, or I want to give 50% of my estate. Percentages are oftentimes a better way to do distributions even among the family and friends that you care about, because our estates go up and our estates go down. Our values in our houses go up and then we have crashes and they go down. And if you had dollar amounts in your will that added up to most of the value of your estate at a peak in the market, and then the market goes down, you're going to be short. And so percentages are oftentimes a really good way to include not only your friends and family, but also charitable organizations in your will. And in your will, you can also include charities as contingent beneficiaries. Well, I really want to give my estate to my spouse, but if my spouse doesn't survive me, and we don't have kids or kids that we want to give our money to, I want to give charities my estate at that point. So you don't have to disinherit the important people who you know will need your assets if you die before them, while still including charities if they're not around when that time comes. Any good plan is going to have contingencies built into it, and oftentimes that's a very good place to include charitable organizations for the contingencies. When the most important people for you to take care of in your will are not around anymore, maybe it's better to give to charity. I generally think it's probably better to give to charity than it is to give to cousins or sort of the nieces and nephews that you haven't seen since 3 Christmases ago because they happen to be in town. I have aunts and uncles. I don't expect to inherit from any of them. I expect them to give to their immediate family, and if they're not around, I know my uncle's very active with the Historical Society in his hometown. I know that that's where his dollars will go. And most of your more distant relatives also don't expect to inherit from you. Think about whether your dollars can best go to some of those family members, or whether they can better go into your local community, into organizations that you care about, charities that you know are doing good things. And it's important to take care of our loved ones, but it's also important to give back to our community when our loved ones don't need it anymore. One of the final things I'll say before lunch, because I think they're getting pretty close to setting up here, is that there are so many ways that you can give to charity and still benefit now that are way beyond the scope of this conversation. There are charitable gift annuities, and there are charitable remainder trusts, and there are charitable foundations, and there are donor-advised funds that you can set up with the Seattle Foundation. There are lots and lots of ways to give to charity at your death, benefit from it now, get the charitable deduction now, that are beyond our conversation here. But if you have questions about those things, if you want to do that kind of planning, that's the perfect thing to do a little digging online. Go look at the Seattle Foundation's website, look at the websites for some of the organizations that are here, and then come talk to the attorney and say, this is what I'm thinking about. How can we best accomplish this? It's oftentimes not the first thing that clients come to me telling me that they want. I want to give some money to this charity, and I want the tax deduction now, but I want to keep some of the dollars. Those are valid and very reasonable plans. If they come to me and say, well, I want to put the charity on as a beneficiary of my retirement account, that's also a valid plan. Knowing what your whole situation is, knowing what your charitable intentions are, knowing what your potential need for those dollars is going to be while you're alive, is information that the attorney needs so they can help you find the best tool to fit with your plan and to make sure that your wishes are carried out, and that you're not giving away dollars that you're gonna need to spend, and that you're making sure to take care of the loved ones and still take care of the charities that you wanna take care of. So, a good plan is well thought out and coordinated with an attorney who can help make sure that your wishes are met and that what you want to have happen is efficiently and effectively built into your plan. Lunchtime.
Thank you, Heather.
So do not fear, you're going to hear more from Heather in just a few minutes. I invite you to do a couple of things. One is to help yourself to our delicious lunch. You may have already noticed on the back of your agenda that there are a series of questions that we may not get to all of today, but that we can touch on. You may have also noticed on your table there are some 3x5 index cards and some pens. So while you're enjoying lunch, I invite you to write down any questions that you have for Heather, and I will go around the room at about 12:15 and collect those cards, and we will ask Heather to begin our afternoon or after lunch portion with those questions. All right? Everybody, bon appetit.